All right, good morning, everybody. Welcome back to day 2 of Spring Conference. We're glad you could join us again. We've got Will and Marlise and Tyson that are going to do our legislative update today. We're seeing the effects of Corona. Will's self-inflicted haircut. It looks awesome. In person, it looks great. Tyson spent the day yesterday in his hammock with a computer. So if he looks a little red in the camera, it's not the camera, it's really red. Marlise, Marlise looks great as always. For those of you that are joining us for the first time today, just want to make sure that you understand about completing your CLE, or excuse me, your course evaluation to get your CLE. For your attorneys, when you go in, actually for everybody, if you have not paid, you won't be able to complete the course evaluation yet. We're leaving the evaluation open for a substantial period of time. So once we get payment, you'll be able to actually go in and complete the evaluation. But for those of you that are paid, go in and get it done as quickly as you can. A reminder for prosecutors, you will have that survey that you'll need to fill out. And as I mentioned at the close of the day yesterday, our civil attorneys, we forgot to take into account that you would be getting this survey, but it doesn't really apply to you. So if you will just email Ron Waite, my IT specialist, he will check the box that you're a civil attorney and you won't be asked to complete the survey. We're going to go till 10:30 this morning, so we've got 90 minutes of legislative update. And with that, I'm just going to turn it over to our trio of presenters.
Thank you, Bob. We're here to do the legislative update for the criminal side. We can't promise any strippers or any celebrity cameos like my friend Lance yesterday, but we do have 2 great colleagues here. If you guys want to introduce yourselves.
Go ahead, Will.
I'm Will Carlson. I'm the Chief Policy Advisor for the Salt Lake County District Attorney's Office. I've been prosecuting since 2009, and I want to say hello to the millions and millions of you out there watching the Spring Conference this morning.
And I'm Marlise Jones. I'm the Sex Assault Domestic Violence Resource Prosecutor with Utah Prosecution Council, and I've been prosecuting for 10 years now, I guess, if I do the math real quick in my head. And Will was one of my mentors, so I'm happy to be here with him. And of course, Tyson is awesome. In fact, Tyson and I both worked with you, Will.
Yes.
At the Salt Lake City office. Yeah, so good for us.
And as evidence that you always have to take the bad with the good, you have to put up a little bit with me as well today. Tyson Skeen, TSRP with the Prosecution Council. A couple considerations before we get started here today. And we always say this, we're doing our best to summarize these bills and give you all the information that you need to be able to be successful in what you're doing. But there really is no replacement for going over this legislation yourself. The summaries are there for you. This will be there for you. But if you have questions and you want more details, you really need to dig into these bills yourself. Unless otherwise stated, all this legislation goes into effect on May 12th. We will try to point out the bills that have different implementation dates, but that is the general implementation date for all legislation. And then also this year, something we've added is in the top left corner of each slide, you're going to see a number. That is the page number for the legislative summaries. So hopefully making it easier for you if you want to go back and reference or if you want to follow along to be able to go through that. So without further ado, we'll get started here. House Bill 98, the Offenses Against the Administration of Government Amendments. You may recall last year a bill that I colloquially labeled the Making All Public Employees Felons Act. Well, now we have the Making All Public Employees Misdemeanors Act.
That's better.
It's better, and maybe not totally accurate to term it that way, but there has been some walking back. So you'll remember public property was added. If you took a pen from the office in your home in your jacket and it ended up in your personal drawer, that was a misuse of public property at the time and could be a second-degree felony. Now we know that probably wasn't ever going to get prosecuted that way, but that was how the law was written. We have walked that back a little bit. So there is a de minimis use provision that has been put in that legislation this year, that if it's de minimis personal use of public property, that is an authorized use under the act. And then it also goes out to spell out the amount of loss for the public entity when a public servant uses public property for personal use for future. And it kind of, for the most part, tracks the criminal mischief and the theft provisions. So less than $500, start off at a Class B misdemeanor, $500 to $1,500 Class A, moving up to secondary felony when it's over $5,000. The one exception to that is if the use or the unauthorized control over the property is only, the intent was only to temporarily deprive the owner of that, then it starts at a Class C misdemeanor and works its way up from there. But that is walking back the Making All Public Employees Felons Act bill to make it a little bit more equitable, I guess, a little bit more reasonable. It's still not a free-for-all that you get to go take your public property that your offices have provided and use it for personal use. But this does make it a little bit more reasonable and allow for what is probably a common practice of at least de minimis personal use of public property in your official capacity.
House Bill 142. This is the criminal proceeding amendments. It's targeting domestic violence and DUI cases. This is going to have the greatest impact on our justice courts and misdemeanor courts. In a number of those courts, a defendant could come in, enter a plea before a prosecutor was even involved in the case, and then move on. In talking with Representative Pitcher during this process, she wanted to make sure that we were able to have eyes on these cases to make sure that any pleas entered are appropriate and that we can have an opportunity to charge it appropriately as well. So it's not just accuracy, but it's also the efficacy of justice. So what this does is prosecutors must approve any plea or no contest plea prior to it being entered on a domestic violence or a DUI case. So that can be done in court, it can be done in writing, or it can be done in another acceptable means of making a record. In DUI cases, this bill also discusses and requires prosecutors to look at their criminal or the driver's criminal and driving history, which I'm confident has always occurred. But we'll be looking at those to make sure that charging accuracy and enhancements have been attached. This does come with some pretty stringent requirements because if this is not met, if prosecutors are not approving these pleas, then the pleas will be deemed invalid. So we want to make sure that we've got eyes on those and that we're making that approval and keeping that record of that approval.
A lot of the legislation that passed this year deals with children. And during the legislative session, one of the videos that came out on YouTube or Facebook, Instagram, was about this little girl that is getting handcuffed by police and thrown into the back of the police car because she was disobeying in class or she had hit her teacher. There was legislation before the session even started that really got a lot of movement because of that video footage, and that was House Bill 262, Juvenile Delinquency Amendments. 262 creates a new age floor for petitions in juvenile court, and that new floor is 12 years of age. So if a child under the age of 12 commits an offense, the presumption is that they will get a non-judicial adjustment, something the equivalent of what the adult court might call a diversion, because a non-judicial adjustment does not even require an admission of culpability or guilt. There are two exceptions to this. The first exception is if a child refuses or fails the non-judicial adjustment, then that case can be screened by a juvenile prosecutor for petition. The second exception is if it's one of an enumerated list of offenses. During the legislative session, there was a lot of talk about this being the list of the most serious offenses. I disagree. What it's called in my book is the Big Ag list, because it's a list of 9 offenses, 7 of which apparently were picked because they start with the word aggravated. The list is aggravated assault resulting in serious bodily injury, aggravated murder or an attempt, murder, which is one of the only 2 that doesn't start with aggravated, or an attempt, aggravated kidnapping, aggravated sex assault, aggravated arson, aggravated burglary, aggravated robbery, or felony discharge of a firearm, not aggravated. Looking at that list, you'll see that aggravated sexual assault is the only sex offense on that list. And so one of the concerns that we raised when this originally was introduced and the floor was set at 11 was that there are a lot of serious sex crimes separate from aggravated sexual assault. For example, rape, forcible sodomy, and none of those were included on the list. This, in response to this, the legislation did two things. First, it raised the floor to the age of 12, and it also said that the presumptive mandatory maximums for non-judicial adjustments, which are 90 days, which can be extended up to 180 days, will not apply if the juvenile is in sex-appropriate treatment. And so there are a few issues that this bill is going to present that it's important for prosecutors to be aware of. The first is that non-judicials are historically a tool that have been used and applied to low-risk kids. The idea is they're low risk, so let's not put them too much in the juvenile system. That's not the case when you're looking at under 12. They could be very high-risk individuals, but non-judicials are still going to be the route. And so it's important that these non-judicials begin with an assessment and that the probation department look at what the needs of the individual youth are and connect them with the appropriate resources as the terms and conditions of the non-judicial. It's not clear how non-judicials, which do not require admitting responsibility, are going to jive with treatments that require accountability and accepting responsibility as part of the treatment process. This often happens with sex offender treatments. Often when a child under the age of 12 is committing a sex offense, it's because they're mirroring something that they've experienced or witnessed themselves. And so these, unlike the legislator who referred to gangs of 11-year-old rapists roaming the streets, a young child who's committing a serious sex crime needs a connection to resources. But it will be important to pay close attention to make sure that they are receiving the resources they need so that we can avoid recidivism when they do get over that new floor of 12 years.
House Bill 335, Illegal Activities on Trust Land Amendments. This is a bill that's simply bringing SITLA land, your school trust lands, into the same protections as county and city lands when they are damaged by private individuals. This case really came about because somebody bulldozed a road across SITLA lands, and based upon how the law was previously written, all they could do is charge a Class B misdemeanor. So again, the offenses and the level of offense is now tracking the criminal mischief and the theft enhancements when it comes to value. If the amount of damage done to SITLA lands is less than $500, it's a Class B. Class A, 500 to 15, 15 to 5,000 is the felony 3, and then if you're over 5,000, a second-degree felony. So really, it's just bringing SITLA lands into the same level of protection as all other publicly owned lands, I guess, when we go to that.
House Bill 206. This is bail and pretrial release amendments. It is a long bill, so settle in, buckle up. I'm going to touch on 8 aspects of it, but there are more in the bill. This is one that affects all of us as prosecutors, so you're going to want to read it. I'll also note up front and then remind again at the end that this does not go into effect until October 1st of 2020. So it's not following the May 12th pattern. It'll be October 1st, 2020. So first of all, you can now plead guilty in October. You can plead guilty on any offense that is a Class B or lower on citation without the requirement of filing an information. This is not inclusive of domestic violence cases, DUI cases, DUI metabolite cases, victim cases, or restitution cases. But any of the other cases, if it's a Class B or lower, it can be pled to without an information being filed. Also, pretrial status orders. This is a new order that's created that'll be issued by the courts during the bail hearings. Its purpose is to provide for the pretrial release conditions. The courts are mandated to issue it without unnecessary delay. So what this means is if you have someone in custody and you don't want them to be released on the court's conditions quickly, and you want to have a voice in what those conditions are, you'll need to file a motion for detention. File that immediately so that the court is aware of your concerns about the pretrial release and a hearing can be set, and that will trigger that hearing process. If a pretrial release is going to occur, the court is limited to imposing the least restrictive, reasonably available conditions of release. And those conditions are to address three things. First of all, it's to ensure that the person will return and appear in court. Secondly, it's to ensure the safety of witnesses and victims. And then thirdly, it's to prevent the obstruction of criminal justice process upon their release. If the court does not have concerns for any of those three conditions, then the person shall be released on their own recognizance. Moving on to bail. If this is part of those pretrial release conditions, the courts now have to, and I believe that they were doing this before, but this bill provides that they have to consider the ability to pay on those bail amounts that are set. There is the opportunity for courts to detain people pretrial. That's not been removed through this bill. There are certain felony circumstances where they can be detained, and also domestic violence cases if the suspect is believed to be a substantial danger to the victim. So the courts can detain a person pretrial for those reasons. There's also a presumption of detention on any first-degree felony offenses and criminal homicide. So the presumption there would be to continue with detention. Now let's shift and talk a little bit about bail bond forfeitures. Before, the funding received from bail bond forfeitures would go to the state general fund. This has now been dispersed differently with this bill starting in October. 15% of the forfeited amount will go to the prosecuting entity that raised the cause of action, 25% to the state general fund, and then 60% will go to CCJJ's pretrial release program special revenue fund. The money from this fund is going to go to enhancing and providing additional pretrial release services. So the benefit of this and the take home, particularly for justice courts and misdemeanor courts, is prior to this, the statute did not allow for any funding to trickle to us other than through the general fund allocations. But now this will allow for 15%. So there's a moderate incentive to be pursuing these bail bond forfeiture actions. I would encourage you to look into it. I know when I was prosecuting here at Layton City, we did it for a while, and after fighting on a few cases and being successful and unsuccessful both, and then getting no financial benefit for all the time and effort that went into it, we had to reassess and would only proceed as was allowed. And with our caseload, we just didn't have the resources to proceed. So this now changes that. It does allow for some of that financial benefit to trickle to the other prosecutors. There's also some timing changes. One notable one is when you file that bail bond forfeiture action, the bail bondsman has 6 months to bring the defendant to court. That has now been limited to 90 days, which is good. Get them out there and bringing these folks to court and or moving on with the forfeiture process. And then just a reminder again, read this bill. There's a lot of information in there, and it goes into effect October 1st, 2020.
So if 262 was the juvenile floor, then 384 is the juvenile ceiling. The goal of this bill is to keep juveniles in juvenile court. Right now, at least until mid-May, there are 3 different ways that a juvenile could end up in district court, in adult court. There's the direct file process. If a 16 or a 17-year-old commits murder or aggravated murder. There's the serious youth offender process, where the presumption is that they go into district court, but they have to be someone who's committed offense on that big ag list that I mentioned earlier. And then there's the certification process, where the presumption is that the juvenile stays in juvenile court, but can, if the court is convinced, be transferred into the adult district court. That whole system is severely changed, or drastically changed, not severely necessarily. The district court will still be able to receive direct file if murder or ag murder is committed by a 16 or 17-year-old. But the serious youth offender process, where the presumption is that a juvenile does go into district court, is eliminated. And the certification process is severely restricted. The way the new certification process works is it has to be a qualifying offense, which means it's got to be one of those on the big ag list for a 16 or a 17-year-old. If it's somebody who's 14 or 15 and you want to get them into district court, they have to have committed murder, aggravated murder, or an attempt of one of those two. So short of murder or ag murder or an attempt to commit it, a 15-year-old will not end up in district court when this law takes effect. But either party can also ask the court to retain, the juvenile court to retain jurisdiction over that juvenile until the age of 25. So what this means is that for a juvenile court judge to send a 16 or a 17-year-old who committed one of the big ag offenses, or a 14 or 15-year-old who committed murder or ag murder into district court, they not only have to have essentially a prelim where they conclude that there's probable cause to believe the offense occurred, but they also have to find by a preponderance of the evidence that the juvenile court would not, retaining jurisdiction, would not serve the best interest of the juvenile and the public. And that's even if you extend jurisdiction for the juvenile court to the age of 25. So the presumption is no transfer. You've got to convince the judge that it's against the interest of the juvenile and the public to keep the juvenile in the juvenile system, even if you extend jurisdiction to the age of 25. Functionally speaking, what this means is if it's not a direct file, you will be very unlikely to get the juvenile into district court going forward.
House Bill 139, DUI liability amendments. This is another bill that has a different implementation date. It's July 1st of 2020. So this won't go into effect until July 1st. It's my belief that it's always been clear in statute that DUI is a strict liability law. However, recently we've had some troubles with that. There have been some judges that are reading in an inherent mens rea, focusing on some of the language in the Byrd case that came out recently. And even our Muji committee published Muji instructions in January that had a knowing, intentionally, or reckless standard for the mens rea when it came to DUI. However, in the note, they acknowledge that this isn't a settled area of law and to proceed with caution.
I've never seen a model instruction that says this instruction might not be true.
It's odd,
Yeah.
certainly. Certainly was odd to have that. So this bill, the first thing I want to talk about that this bill does is it makes very, very clear that DUI is a strict liability offense. Puts it right in 41-68502 that a violation of this section is a strict liability offense. So that will hopefully put to rest any of the arguments that have crept in recently in regards to the mens rea. It also clarifies, which also was still clear in law, but we were having problems with, that DUI cannot be held in abeyance, and that also that an admission to 41-68502 in juvenile court, even if it's subsequently dismissed, it still counts as a conviction for enhanceability purposes later on. It also cleans up the wrong way DUI provision. You remember a couple years ago we passed a law that if you're driving the wrong way on a freeway, it's a Class A misdemeanor, DUI. The wrong code section was referenced in that. This cleans that up and makes it, it's not any change on what the intent was supposed to be, but it does clean that up. There's also a change, some language put in on actual physical control in this. And so basically the statute will now read, the actual physical control is based upon the totality of the circumstances. No change from where we've always been. We've always been on the totality of the circumstances. And then it also does not include when all of the following are present. So not when any one of them, but all 5 of these factors have to be present. 1, the person has to be asleep inside the vehicle. The person is not in the driver's seat of the vehicle. The engine is not running. The vehicle is lawfully parked. And under the facts presented, it is evident that the person did not drive the vehicle to the location while under the influence. As I look at that, and as I was contacted as this language was getting put into the statute, I was asked, does this change anything? I don't think we would have ever proved actual physical control when those 5 things were all present. The person, it's clear based upon the evidence that the person did not drive there under the influence. Okay, they're not in the driver's seat. They're asleep. The car's not running, and the vehicle is parked legally. I don't think we were ever going to get actual physical control under those very, very specific circumstances anyways. So I don't view this as any change. I've actually had a couple calls from officers about this, and I've told them, proceed as normal. I just don't see this as any change. If, however, all 5 of those are there, and you have a case that comes to you on actual physical control, by law, it is no longer actual physical control. So you'll need to be aware of that. The last thing that this bill does, and probably the largest change for what we're talking about here, well, really, it is the largest change for what we're talking about here, is the criminal refusal that is now in place. This came up because we're having situations around the state where forced blood draws are becoming violent encounters, essentially, with people. When the officers will go and get a blood draw warrant and the person says, "You're not taking my blood," and they're having to force that. In some instances, some places, they have restraining chairs and they're able to do it relatively easily, I guess. I'll use that word relatively again. But other places, it's become a wrestling match with somebody to be able to get blood. And that is not a safe situation environment for our officers or for the suspects, and we don't want that. And so essentially, what we have here is we have a new code that was created that if after the admonition is read, so that is a factor that has to be in, the admonition absolutely has to be read, and a warrant has been issued to draw that person's blood. If that person still refuses, it is a criminal violation now to refuse that, not just the administrative sanction, but now a criminal sanction. Each of the penalties on this have been enhanced as well. And so if it's a felony DUI that you're investigating at this point, it would be a felony refusal. If it's a Class B DUI that you're investigating, it will be a Class B level refusal. However, any jail sentence that comes shall be 24 consecutive hours, so an extra day of jail than the DUI would have been, and $100 more fine. The idea behind this is essentially we're telling people it would be better for you to get a bad result than to refuse. That's the legislative intent here, essentially, is we do not want forced blood draws. Another thing to keep in mind with this is DUI and this criminal refusal of a blood draw do not merge under the statute. Both charges can still be charged in the case, and I would encourage you to charge both if you have the evidence to be able to do that. If they have decided not to take the blood and there's still enough evidence to proceed on the DUI, you should proceed on the DUI as well and charge both cases or both offenses. Also, a criminal refusal counts for enhanceability purposes for DUI. So if somebody has 2 criminal refusals on their criminal history in the last 10 years and they're pulled over for DUI, that third is a felony DUI offense. So they've done a really good job trying to make this close all the loopholes and different things that we at least could see might have happened in this to make this so that we don't have to do these physically violent encounters to physically take somebody's blood. This only applies to the blood. If somebody refuses a breath test, it is still just an administrative sanction. And just to reiterate, it's only after the admonition has been read and a warrant has been issued. That was an important part based upon Birchfield that came out a couple years ago from the United States Supreme Court, where they basically said that to do a blood draw, you have to have a warrant. You can't, implied consent doesn't get you behind that. So we have to have a warrant in place as well to be in compliance with Birchfield on that. But a great change, I think, that will help these violent encounters reduce, but also give us another tool as we're moving forward with this.
House Bill 213, consent language amendments. For those of you that do SVU cases, special victim cases, you're aware that our consent statute is more of a lack of consent statute. Establishing what is consent is a highly charged constitutional discussion. We had hopes and a lot of discussion with this bill. We've come away with some additional help on these cases to protect victims, but that discussion still continues. So if you want to challenge your constitutional analysis as to what consent can be identified that it is, we're always open to that information, and this discussion will continue. Some states have established consent statutes to define what it actually is, and they've come up against litigation against it because it's a difficult issue. But with that being said, within our parameters of what consent is not, there are some additional changes that are helpful and helps to protect victims. Previously, we had indicated, or it indicates that consent cannot be given if the victim participates because they erroneously believe the actor to be the spouse. Well, that has now been changed for the wording to include erroneously believe the actor to be someone else. Obviously, there's a lot of circumstances where someone might engage in sexual activity with a boyfriend or a love interest or someone they're living with or a friend, and believe that it is them. And so that needed to be broadened to include more than just someone's belief of a spouse. So any misidentification, not just spouse, is now included in that. A couple other additions towards the end of this statute, if you're looking for it in the actual enrolled law. Consent to any sexual act or prior consensual activity does not constitute consent to any other sexual activity. So consent for touching does not mean consent for any other sexual activity during that interaction. And then the third one is consent can be withdrawn at any time prior to or during the sexual activity through words or conduct. That's tied to the through words or conduct, as is one of the first provisions in the statute that says consent is not given through words or conduct. The unfortunate thing is our neuroscience has strongly established that many victims in these sexual assault situations are unable to convey their lack of consent through words or conduct. And so that is problematic. And there are certainly victims that were not able to lead the charge for justice for them. But that's why the discussion will continue, because we've got to find a solution. We're continuing to search for that solution. But for now, it does rely on words or conduct to indicate that there is a lack of consent, and withdrawal of consent also relies on words and conduct.
The sexual exploitation of a minor statute is Utah's child porn statute. And unlike drugs, where possession is one level, distribution is a higher level, the sexual exploitation of a minor statute has a similar penalty regardless of whether it's possession, use, distribution, or production. There's an affirmative defense already in the code for child porn that says if the person depicted was not a minor, then that is not an offense. This bill adds a new affirmative defense. And the saying that bad facts make bad law is fair here, except this may not even have been based on facts as much as a story. So bad stories can make bad law. This new affirmative defense says if the only offense is possession or viewing, and if the person who is possessing or viewing did not solicit the child pornography, and if the defendant is less than 2 years older than the depicted minor, and if the defendant destroys the child pornography upon request of the law enforcement agency or the minor, and if the child porn does not depict an offense under Title 76, Chapter 5, Part 4, which is the sexual offenses portion of the code, then that is not sexual exploitation of a minor. This was based on a story, perhaps apocryphal, of a teenage boy who received a picture of his classmates' girls' volleyball team in a hot tub with their tops off. He kept the picture. He didn't ask for the picture. It was airdropped in the cafeteria, according to the story. But because he did not delete it for 11 days, he was charged with exploitation. With the passage of this legislation, that apocryphal teenage boy will no longer be guilty under this offense.
Apocryphal.
Yes.
I like that word.
We got to keep up with John and Lance yesterday with all their correct verbiage.
I don't speak Latin. House Bill 84, Traffic Code Amendments. This is all about the penalties for illegally passing a school bus. The legislature, we've seen lots of news stories about this actually the last few years, where this is a continuing problem and maybe even an increasing problem. So the legislature is trying to address it. First offense of illegally passing a school bus when the lights are flashing or the stop sign up is a $250 fine with 10 hours of compensatory service. That's mandatory. Both of those are mandatory. A second offense within 3 years is a $500 fine and 20 hours of compensatory service. And a third or subsequent offense within 3 years is a $1,000 fine and 40 hours of compensatory service. So for those of you who have these cases coming through your justice courts, realize these are minimum mandatory penalties that go along with that based upon the code now.
You know, we had a case here many years ago where a guy pulled out and passed a school bus and plowed through a group of kids crossing the street and seriously, life-changingly injured permanently a young woman. And it's one of those cases I'll never forget. It was tragic. Okay, school threats. House Bill 171. This is a new statute that criminalizes more specifically the issue we're having with threats in our schools. So a couple definitions. Schools are defined as preschools as well as public or private elementary schools and secondary schools. Threat is defined as being a threat in person or electronic communication, and whether it's with real intent or as an intentional hoax. So these threats in the school setting as defined rises to a criminal level if, and there are two categories. The second one has some subcategories. First of all, it involves a threat to commit bodily injury, death, or substantial property damage. And the second is A, threatens use of a firearm, weapon, hoax weapon of mass destruction under 7610-401, or acts with intent to disrupt school schedule, which is a Class A misdemeanor, or occupancy of school or its facility or vehicle, a Class B misdemeanor, or intimidate or coerce students or employees, which is a Class A misdemeanor, or cause an official or volunteer emergency response agency to take action due to the risk to the school or general public, a Class C misdemeanor. So there's a lot of variations of how these threats occur, and this bill has tried to address those in as comprehensive as a way as possible. It is not a defense if the person that has made the threat either does not attempt or is unable to follow through on the threat. That is not a defense. If the threat is made, then it's potentially chargeable under this statutory provisions.
The standard statute of limitations for most felony offenses is 4 years from the date of the offense. This bill, House Bill 247, creates an unusual statute of limitations that's not based on the amount of time since the offense, but on the age of the victim, and the magic number is 28. This statute of limitations bill only affects two statutes, and that's unlawful sexual activity with a minor and unlawful sexual conduct with a 16 or 17-year-old. In layman's terms, it's when you have quote-unquote consensual sex between a teenager and an adult. If that conduct is a felony, meaning for the 14 and 15-year-old, if the defendant is over 21, or for the 16 and 17-year-old, the defendant is at least 7 years older and either knew or should have known, or is 10 years older than the minor, then the statute of limitations, rather than being 4 years from the date of the sexual act, is until the victim reaches the age of 28 years, or 10 years after the victim reaches the age of 18. The research about sexual assault on children indicates that the average age for a disclosure is 40. So for teenagers to have at least a little bit of time after they've reached adulthood, and after, based on what we know about the human brain development, they've had some time to think about what has happened to them and about how the idea that a sexual interaction between a young teen and an adult is not as consensual as it might appear. This bill is very important because it gives those kids more time to think about what happened and report, and for law enforcement and prosecutors to take action when appropriate.
That's a great bill.
All right, we're going to dive into medical cannabis here. And Bob, there's a really good chance I'm going to need some Funyuns when I'm done with this. So if you could help a brother out, that would be very helpful. There were two bills that addressed this topic in the legislature this year. The first is Senate Bill 121, the medical cannabis amendments. This is from Senator Vickers. Ooh, Doritos are the next best thing.
Only have Doritos.
Next best thing to Funyuns is nacho cheese Doritos, which will come in very handy. Thank you, Bob. Senate Bill 121, which went into effect on the signature of the governor on February 28th. So already in effect. It was followed up with House Bill 425 from Representative Daley Provost. It went into effect on signature of the governor on March 24th. So everything we're talking about right now is already in law. It's already in provisions. Some of the things that came in House Bill 425, well, House Bill 425 was intended as a cleanup for everything they didn't get right, that they realized immediately they didn't get right in Senate Bill 121. And so some of those things were only in effect for about a month. We're going to talk about this just in general. I'm not going to go in and separate what they do, but just in general. There is a lot in this bill. And this topic alone could be its own presentation for a conference. So don't think you're going to get everything that you should get out of this from me today. I'm going to go through it very quickly and hit on what I, in my opinion, view as the most important parts of this bill, which means I'm not going to touch any of the licensing, any of that, the administrative stuff. So for the civil attorneys listening, I apologize, but sorry, not sorry. That's not my cup of tea, and that's not where I'm at. So, but you really are going to want to go in and look at this. Your officers are going to have questions on what they can enforce, what they can't enforce. You're going to want to know what's going on with this. So take a look at this bill. However, I will highlight what I think are the most important parts. First, 416A517, the driving with a measurable controlled substance statute, what we affectionately call in our business the DUI metabolite statute. There is a change in what is considered a violation of that law. If the only substance that comes back on your test, whatever your chemical test is carboxy-THC, which is the metabolite or the non-psychoactive metabolite of THC, that is no longer a violation of 416A517. Okay? That means that if the only substance or the only chemical test you did was urine, all you're ever going to get is carboxy-THC out of urine. And so that's not going to be a way to prove the metabolite law anymore when it comes to marijuana specifically. This is something that was intended as a bit of a compromise, to be honest, having been a part of some of those discussions and hearing what went on. However, all the things that we were promised, none of them happened. And so it's interesting to see where this went. However, I don't think that this is the end of the world. One thing that we need to make sure is for officers who are listening or anybody else who's working with these, it will make it imperative that the officers get the blood as quickly as they can if they suspect marijuana is on board. Now, I'm not saying consider that an exigency. I'm not saying that. Let's make that very clear. But once you have that warrant, get a warrant as quickly as you can. If you have consent, get the blood as quickly as you can and get that blood. Because the way that THC metabolizes in the body, and we're not going to have a scientific discussion here too deeply, but it is lipophilic, means it does not metabolize in the blood. It leaves the blood very quickly. And so the things that we get most often are the metabolites of that. The flip side of this is there is another psychoactive metabolite of THC that our state toxicology lab previously had not tested for. That's the hydroxy-THC. When this bill was going into effect, we talked with the Tox Lab. They said that they could change their protocols over to start testing for hydroxy-THC. And I just got word earlier this week from Matt Slosson, the director at the lab. They are now testing for hydroxy-THC. So you'll probably see that on your blood results. They're not going to stop testing for carboxy. They will still test for that. Just for this one statute, it no longer meets the definition of driving with a measurable controlled substance. However, if it is hydroxy-THC, which still is a psychoactive metabolite of THC, it is still against the law to do so. Much more problematic than the change there under this law is the change in mens rea to the driving with a measurable controlled substance when we have serious bodily injury or death. Now, under 5837.8, all Schedule 1 and Schedule 2 controlled substances, if a person knowingly or intentionally had the controlled substance or the metabolite of a controlled substance in their body, and they committed a negligent driving act which resulted in a serious bodily injury or death, that is a second-degree felony. You might remember some of the discussion on the Ainsworth case when it came to this topic. That was upheld once it went up on appeal, that was okay for the legislature to do this. It's a second-degree felony for all Schedule 1 and Schedule 2 substances except marijuana, which is a third-degree felony. That's how the law had previously read coming into this session. One thing Senate Bill 121 did is instead of making marijuana equal with others, it left it at a lower level, but it also changed the mens rea. So no longer is it a negligence standard, it's a criminal negligence standard. So not only is it less of a penalty, it now has a much higher standard to meet for the mens rea to be able to even prosecute that charge. That was one of the things that we were told was going to change.
Once, twice, 3 times.
And every time it either disappeared out of a bill or the bill got shot down. I think this needs to be a high priority as we move into next legislative session. This is going to make it really difficult to prosecute marijuana-involved fatality and serious bodily injury cases under this statute. Now, we still have DUI, we still have others that doesn't apply to, but if we're trying to go under 5837.8, where we do that, it's going to make it really difficult to prove criminal negligence in these cases. So I think that needs to be a priority. That's gospel according to Tyson. Next, what this bill does. There is updates to the medicinal dosage form definition. There's some updates to the oils and waxes. It used to be that for oils and waxes, you needed to have tried 2 other treatments previously that were confirmed not to work, 2 other types of treatment or forms before you could go to an oil and wax. That has been removed. So you can go straight to oils and waxes now, which for anybody in the business, that's the good stuff anyway. So why would you want to go anywhere else? Unprocessed cannabis flower, which is your raw marijuana, used to have to be contained in a blister pack with very specific labeling and weights and things. That has now been removed. They now need to be kept in a container, which is described in statute, which is basically tamper and resistance proof, child resistant proof. The container cannot appeal to children. It can't be packaged like candy, must be opaque, and it must contain a warning label, which basically has all the same warning labels as your other medication. Do not drive or operate. This might be addictive. I don't know. I don't remember the exact language, but just like any other medicine you may take, a warning label that is there. Senate Bill 121 added a legal dosage limit, and as part of that, it actually had a legal termination date. So on the label of your marijuana, you would have to have a date where it became no longer legal, essentially. So people should be using their supply that they've been given for their medical treatments, and then once it got past that date, you wouldn't be able to legally possess it out of your home anymore. House Bill 425 removed that, so that was only law for about a month. It's no longer there. However, there is still a legal dosage limit under the guidelines, the supply guidelines, the dosage guidelines that have been presented. Doctors are only supposed to be supplying a 30-day supply of medical marijuana product. For raw marijuana, that cannot exceed 113 grams by weight or in any form of THC, no greater than 20 grams of active THC. Good luck on that one. It's possible to test for those, but not easy. Another thing that this does is, except for an emergency medical condition, medical marijuana products may not be used in public view. All right? These have to be done and used in private. A first violation of this is an infraction, and any subsequent violation is a Class B misdemeanor of the public view violation. This bill also exempted anybody who's under the influence of cannabis that is complying with the Utah Medical Cannabis Act. So if somebody is in full compliance with the act, they've taken their cannabis, they're high, which is what's going to happen if they use their medical cannabis that contains THC and other things, they no longer can be prosecuted for carrying a dangerous weapon under the influence of alcohol or drugs. So it exempts lawful medical cannabis users from that provision of 7610.528. Previously, non-residents and residents of Utah have been treated pretty differently under the Utah Medical Cannabis Act. They still are, but this makes it a lot closer. So a non-resident patient is a new definition under the rules, and basically that is a person who's not a resident of Utah that has a medical card from their own state. That makes them a non-resident patient. If those people have a medical card from their own state and product from their own state, even if it doesn't meet the definitions of our code. So one thing is how it was previously, is everybody still had to comply with our code. Even if they were a non-resident, they had a medical card from Colorado, their marijuana still had to comply with the Utah Medical Cannabis Act, whatever form it was in. Because we know Colorado has much more loose, obviously they're open for recreation, but even what they term medical marijuana, they have much more loose restrictions than we do, meaning they have none and we have some. So it used to need to comply, but even if it doesn't comply with our medicinal dosage form, their illegal possession for a first time is only an infraction. So we wouldn't charge them under the Controlled Substance Act, we'd charge them under this for illegal possession as an infraction, and then any other subsequent offense now triggers prosecuting them under the Controlled Substance Act. So a Class B misdemeanor or however it would fit under the statute. On that note, most violations for cardholders, so violations of the Act, there's a lot of little infractions along the way. But essentially the legislature for cardholders that are coming close to complying, most violations are going to be infractions. You're not going to see a lot on top of that. Smoking is still not allowed. Smoking is not a form of medical use under this code previously and now. But if a card holder does it, so if a medical cannabis card holder does it, the penalty for a first offense is a class or an infraction with a max fine of $100, and then any subsequent offense for smoking will be a Class B misdemeanor. There are multiple other opportunities for expungement under this. It creates new expungement opportunities. Say somebody got a possession of a controlled substance charge sometime in the past, before any of this went into place. If they would have qualified under today's rules at that time for a medical card and they would have been compliance in the Act, they have the opportunity to get an expungement for that. So at the time of their arrest or citation, even if it was 5 years ago, if it would have qualified at the time, under today's law, they can go and get those previous offenses expunged. The onus is on them to be able to prove that, however. It's not, prosecutors won't have to prove that it didn't apply. They have to make a showing that it would have applied to them. One note for law enforcement, the e-verification system. There's a little bit of a change to the e-verification system. It is still a felony to access that for any unlawful purpose. So do not access that. You know the procedures of PCI, same deal, except for you're getting charged with a felony, not a Class B misdemeanor when you access PCI. This new law comes out and it makes a change when law enforcement officers can access the e-verification system without a warrant. So in any law enforcement encounter, doesn't matter what the nature of the encounter is, if you need to verify if somebody is a medical cannabis card holder, you may access the e-verify system without a warrant. And you'll do that through their driver license, through their state ID, however you do it, however you connect to your CGIS, you'll be able to see that. Any other reason that you would access the e-verify system, you will need a warrant to be able to go in and get that. So just be aware of that. Again, this is a massive amount of legislation that passed, and there's a lot of technical things, there's a lot of administrative licensing things that I didn't even touch on. If you are working anything to do with this in the criminal administrative world, go and look at this bill. Take a look at it, break it down, outline it, make sure your officers know what is and what isn't kosher going forward, because this is going to be a big deal as we move forward. There's a lot going on with it. Like I said, we could spend an hour talking about this alone, but we have a lot more that we need to talk about here today, so we will move on.
Okay, moving on to human trafficking, House Bill 291. This bill requires the Attorney General's office to offer human trafficking training to law enforcement officers. It's an amendment within what began as HB 200 back in 2017 where we, Utah Prosecution Council, and POST collaborate to offer training for sex assault and domestic violence to law enforcement officers. Now they've added human trafficking training. Because the Attorney General's office has been leading out on prosecuting those cases, they'll be the lead on this training, and they'll collaborate and partner with us and POST as well to make that happen. This bill also makes human trafficking a registrable offense, which is a good thing. And then it strengthens safe harbor provisions that have been previously established. So last year, you may remember we had a couple bills that addressed human trafficking. and children, meaning individuals under the age of 18 who may be engaged in this commercial sex industry. They are to be treated as victims. No questions asked. They're to be treated as victims if they're under the age of 18, and they're not to be adjudicated or prosecuted for prostitution or sex solicitation or human trafficking. Rather, they're to be referred to Department of Child and Family Services for intervention and resources.
Controlled substance penalty enhancements deals with engaging in a continuing criminal enterprise of drug distribution. This is only filed about 8 times per year. And in the last 5 years, I think only one defendant has actually entered a plea or been convicted statewide of engaging in a continuing criminal enterprise of drug distribution. However, in the event that somebody's convicted of that, it is a first-degree felony with a criminal penalty of 7 years to life. This is an illustration through this legislation of how JRI was not just about decreasing criminal penalties, but making sure the right people receive the right penalties. Because this bill, supported by Representative Eric Hutchings, the author of JRI, increases penalties. If you're engaged in an ongoing criminal enterprise of drug distribution, and you know or should know that one of your subordinates is under the age of 18, so if you've got child drug dealers working for you, then that 7 years to life becomes 15 years to life. There's a carve-out. You cannot go after boss baby with this bill. If the child or if the defendant is under the age of 18, that 15 years to life penalty does not apply. But referring back to the ceiling bill that I talked about earlier, engaging in an ongoing criminal enterprise is already not on the big ag list, and so you wouldn't be able to keep that juvenile under your jurisdiction for 15 years anyway. So there's no real loss in that scenario. But this is a bill that increased criminal penalties this year.
House Bill 151, the picture you're looking at on the screen right now really doesn't have anything to do with this bill, but Marlise challenged me to use it, and challenge accepted.
I think it's hilarious.
So
I laugh every time I see it.
really, very, very quickly, this increases the apparent property damage value that requires a report to public safety, essentially. If you're in a crash, in an accident, the amount of damage that requires goes from $1,500 to $2,500. There'll also be some provisions where they can paint on the lanes what vehicles are allowed to be in those lanes, whereas signage was usually used before. They're going to start painting the lanes now instead of using the signage.
And there was a crash. That was a crash.
That was a crash.
Okay, House Bill 344, Sex Offender Restrictions Amendments. This bill subjects our sex offenders, our registered sex offenders to victim-requested restrictions from the victim's residence. So this, shouldn't be anything mind-boggling. Basically, it provides that if a registered sex offender is on probation or parole for a registrable offense, the victim or victim's parents can advise the Department of Corrections that they want a restriction around their residence for safety. They would need to authorize the Department of Corrections to instruct and give information to the offender as to what that location is. And then the Department of Corrections notifies the offender in writing of the restriction with a description of the location of the protected area. In looking at it, it doesn't appear necessarily that there has to be an exact address, but it would need to be a very specific indication of what area that offender cannot cross over into. This bill also does another thing, which I think is fantastic. It prohibits sex offenders from serving as any athletic coach, manager, or trainer on juvenile teams. So teams with minors, they cannot be a coach, a manager, or a trainer if there's a minor as a member of that team. Violation of this section is a Class A misdemeanor.
Today is a very special birthday, not necessarily of a person, although I'm sure there are very special people with birthdays today, but of a concept. The Clean Slate Act that passed last year takes effect today. And this bill was supposed to be a clean slate cleanup. to address some things. And up until 11:40 on the last night of the legislative session, that's exactly what this bill was. This bill did two things up until 11:40 of the last night of the session. It made sure that if somebody is not guilty by reason of insanity, that will not automatically be expunged. And in the lifetime caps on the number of offenses a person can have before they can, in order to petition for an expungement, it disqualified those cases that were clean slate automatically expunged. So if nobody had petitioned to expunge a case, the fact that it was expunged did not count against someone's lifetime maximums of getting an expungement. At 11:40 on the last night of the session, this bill suddenly tripled in size and also created a Juvenile Expungement Act. It was introduced by the Senate, on the Senate floor by Senator Weiler, and passed without any discussion. And it was the last bill that passed out of the House on the night of the last night of the session before they adjourned sine die, I don't know. Yeah. But essentially, what this did is it creates a whole new process for expunging juvenile offenses. There is a list of crimes that adults cannot get expunged because they're just too serious. The list for juveniles is murder and ag murder. The end. Anything else, in theory, could be expunged at some point as long as the juvenile meets all the other requirements. So it's a very generous expungement act that did not have the same kind of collaboration or input that other legislation had, but it passed and it took effect today.
Bob, I'm definitely going to need those Funyuns. House Bill 73, can do this one very quickly. Basically, interference with public servants amendments. So people who are serving process, essentially. The protections are broadened. So anybody serving legal process is now protected under this. It does provide a better definition for interference as well. So this is a broadened scope of who gets protection under the interfering with public service.
Crime Enhancement Amendments, House Bill 238. This impacts our possession of controlled substance cases. So a third or subsequent conviction for possession of a Schedule 1, 2, or controlled substance analog, that has a limitation of an enhancement period of 7 years, as does multiple possessions of all other controlled substances, including marijuana and substances listed in 5837.4.2. Those are also limited to 7 years. So take a look at that very clear and easy to follow and understand part of our statute for these changes.
Oh, bouncing back to me.
Yeah.
Woo. All right. House Bill 83, expungement amendments. This was a bill that the Salt Lake County DA's office had originally worked with Representative Stoddard on over a year ago, and this version passed this year. It does two things. Under the previous Expungement Act, a victim was only entitled to notice of an expungement petition if it was a victim of a conviction. So victims of pleas in abeyance were not statutorily entitled to get notice or to object to an expungement petition. This bill does require prosecutors to notify the victims of pleas in abeyance when an expungement petition comes through, but it also does something else. It requires the judge to find good cause before expunging a plea in abeyance that's been dismissed if that plea in abeyance is still enhanceable. What kind of offenses might still be enhanceable if they're dismissed? Well, the number one that we were aiming for is domestic violence offenses. Under the Expungement Act, in theory, 30 days after a plea in abeyance for DV is dismissed, that defendant can apply to get that case expunged. But it's enhanceable for another decade after the event has occurred. Under this bill, the defendant will have to show by clear and convincing evidence that there is good cause to expunge that case if they're trying to enhance it within that 10-year enhancement window. It's not the only it's not only domestic violence that's enhanceable after a plea in abeyance dismissal, though. Drug offenses are enhanceable even after a plea in abeyance dismissal, and so in theory, this could be used on those. And stalking is an offense which, even if a defendant enters a plea in abeyance and has a dismissal, it can be used for enhancement. So for stalking, drug offenses, and domestic violence, There's a new hurdle that defendants have to overcome if they want to expunge that. A judge could still grant them, but they have to have good cause before they do so.
And I think this goes into effect today as well.
Yes, it does. Happy birthday.
Prosecutor data collection. This is a bill that's going to impact every single prosecutor's office in the state. I will try to go through this pretty quickly, but I'm going to give you a scope of what this really means. This applies to prosecution agencies, to jails, to courts. The jails and the courts kind of ended up in another statute, so you'll look elsewhere, but it's going to be similar principles. Essentially, beginning July 1st, 2021, so we're a little over a year out, you have to begin collecting data that includes the following. So on any mandatory court appearance, we will have to collect data and ship these off to CCJJ 3 times a year. The defendant's full name, the offense tracking number, the date of birth of the defendant, the zip code, the referring agency, and whether prosecutorial agency filed charges, declined charges, initiated a pre-filing diversion, or asked the referring agency for additional information. It doesn't stop there. If charges are filed, the following information has to be provided to CCJJ. The court case number and the court where the charges are filed, all charges brought against the defendant, whether bail was requested, and if so, the amount requested, the date of initial discovery disclosure, whether post-filing diversion was offered, and if so, whether it was entered, if post-filing diversion or a plea agreement was accepted, the date entered by the court, and the date of acquittal or conviction, acquittal, plea agreement, dismissal, or other disposition of the case. All that information is mandatory and has to be reported by every prosecution agency in the state. I know that through at least eProsecutor, they're working to try and put in place a way to gather all this information so that it becomes easier for you to be able to do that. But that's probably not in place yet, and hopefully will be. It's going to cost money. It's going to do things. Representative Judkins has promised that this was not going to be an unfunded mandate, that she's going to provide funding. The legislature will provide funding to be able to do it. On top of this, you have to retain those records of all the information collected and transmitted for 10 years. In addition to all that, prosecution agencies are now required to publish their office policies online. And their policies have to cover specific areas, and I'll tell you what those specific areas are. And if you don't have a policy on a specific area, you have to articulate online that we don't have a policy on this specific area. Those areas are as follows: screening and filing criminal charges, a policy on plea bargains, a policy on sentencing recommendations, policies on discovery practices, the prosecution of juveniles, including whether to prosecute a juvenile as an adult, the policy on collection of fines and fees, criminal and civil asset forfeiture practices, services available to victims of crimes, both internal in your office and also that you refer to outside agencies, policies on diversion programs, and any policies on restorative justice programs. Those policies have to be posted online by January 1st, 2021. So every prosecution agency has to post those online and have that available to the public. The carrot or the stick, I guess, when it comes to this, is anybody who is not doing this in regards to reporting to CCJJ this information cannot receive grant funds for the purpose of doing this. Now, I don't want to speak out of turn, but the grants that we have received for eProsecutor have come through CCJJ. I am not sure if they're going to consider that as money received specifically to accomplish this purpose. They might. And so if you're not doing it and you're on eProsecutor and have gotten grant funding, they might come and ask you to repay that. I don't know that for sure. That's probably something we're still going to need to look at. But certainly any future money that is provided specifically for agencies to be able to collect this data, if you're not collecting it and submitting it to CCJJ as instructed, you will have to pay that money back. The sponsor, again, this doesn't go into effect until you start collecting the data, July of 2021. The sponsor has expressed a willingness to work on some of these things in the interim and to fix any apparent problems with it. But this is a massive amount of information that we haven't usually collected that we're going to have to now not only collect, but report to CCJJ 3 times a year.
Okay, House Bill 441, Criminal Charge Reduction Amendments. This bill basically codifies practice in a lot of prosecutors' offices and pursuant to West Valley City v. McDonald. This is where if you have a charge with a severity, for example, of a second-degree felony, and you want to charge that offense with the severity of a third-degree felony, you can do that without using an attempted or some other clarification to bring that offense lower. So you can just charge it at a lower offense. This applies to all charges except capital offenses. It cannot be applied in there, but any other charge you can charge at one offense or 1 degree lower for that offense. Any lowering of an offense that is under the section where there might be registration, so sex kidnap registration, child abuse registration, this lowering of the offense and charging does not change the registration requirements. So if they are charged with an offense that is registrable, then whether you charge it at the severity by statute or 1 degree lower, the registration requirements remain the same. And then this bill also clarifies that either the defendant or the prosecutor can move the court for a reduction under 763402.
House Bill 403 is an object lesson in how simplifying things can get really complicated. The point of this bill was to streamline protective orders, make them accessible and consistent. All protective orders, civil and criminal, starting July 1, which is the effective date of this bill, should end up in Title 78B, Chapter 7. 78B, Chapter 7 is going to have 9 parts. Part 1 is going to be general provisions that apply throughout the chapter. Part 2 is about child protective orders. Part 3 is the Uniform Interstate Enforcement of Domestic Violence Protective Orders Act. Part 4 is the Dating Violence Protective Orders. Part 5, Sexual Violence Protective Orders. Part 6, Cohabitant Abuse Protective Orders. Part 7, Civil Stalking Injunctions. Part 8, and of note to criminal prosecutors, Criminal Protective Orders. And Part 9 are Criminal Stalking Injunctions. Most civil protective orders under this bill will last 3 years and be renewable. That's a big change from the current law, which ranges anywhere from a decade to 150 days, some of which were renewable, others were not. The default for most civil protective orders is going to be 3 years, but they can be renewed. There are, as always, exceptions. Child protective orders will last 150 days still if the respondent is a parent or guardian. But if the child protective order goes after somebody who is not a parent or guardian, that child protective order will extend until the child reaches the age of majority, or 18. Also, criminal protective orders will be based on the standing of the criminal case rather than a 3-year default. Jail release agreements will last until the initial appearance or 30 days. An issue has come up that needs to be addressed in future sessions, and Senator Todd Weiler has agreed to sponsor legislation to this effect. When we created a time limit of 30 days for jail release agreements, we anticipated that an initial appearance would certainly happen within 30 days. We did not anticipate a pandemic where the courts would functionally be shut down and be scheduling months in advance. So right now there are jail release agreements and jail release orders that are expiring before a defendant gets a chance to go into court. That is going to be addressed in future legislation and is not fixed through this bill. Another thing that this bill does do, though, is it creates continuous protective orders as an option for any criminal sentencing where incarceration is at least part of the sentence. So if somebody is sentenced to 10 days jail as a condition of probation, or if they're sentenced to prison, it doesn't have to be domestic violence for a continuous protective order to be in place. The presumption for domestic violence is that a continuous protective order will be put in place, and the presumption for all other offenses is that it will not, but it is an option that's available for prosecutors when necessary. Also, under this legislation, those arrested for violating a jail release agreement, so those who just can't hold on for the 30 days before they violate, should be held until the initial appearance. That's made explicitly clear. So if you have defendants who are committing a violation of jail release agreements during this time when they're supposed to be staying away, under this legislation, starting July 1, the courts and the jails are authorized to hold that individual up until their next initial appearance.
So just a note on that, and Will, you and I talked about it. I reached out to the court. In the history of protective orders, we had lifetime protective orders, and then they went to 10 years, and now they will be 3 years. And in talking to the court, they said that their system, as far as updating UCGIS and keeping it active, will rely on when that order was issued. So, of course, this is not retroactive. This is moving forward. So moving forward, protective orders will be 3 years. So as a tip for your law enforcement that are out there enforcing these orders, let them know, look at the date. It's the date moving forward. If there is no expiration on the order, then the date moving forward will designate whether or not it was a lifetime 10-year or a 3-year order. So we're likely to see some questions on that as far as enforcement.
Especially for older protective orders, because a cohabitant protective order from just 3 years ago could have been a permanent.
Correct, yeah.
Will, by the way, did a ton of work on that bill, and well done.
So I apologize.
Will does a ton of work on every bill.
This is
just so
true.
everybody knows. House Bill 184, municipal regulation of golf carts. This is the fun one. Bob kept asking, why are we going to talk about golf carts? Why are we going to talk about golf carts? Well, this is important stuff, all right? The state legislature has now defined what a golf cart is in Utah code.
What is a golf cart, Tyson?
Well, it is what you see on your screen right now. But it also has exempted it from title and registration and other requirements that are required for motor vehicles. And they have allowed municipalities to authorize by ordinance the people who can operate golf carts and specific roadways or highways in their municipalities where golf carts may be operated. Now, if you're going to do this, municipalities, you have to specify certain things. Which highways or which roadways you're going to allow them on, the hours to which the golf carts can be operated, and who can operate them. One thing to keep in mind is that unless this has been done, golf carts are not allowed on highways. Now, when I told my brother about this, I've got another brother who likes to golf and whatnot. When I told him about this, he said that his retirement vehicle plan is completely shattered now. And he had planned to get a really nice golf cart to be his retirement vehicle, and now that his dreams are shattered. So if a municipality doesn't affirmatively go out and authorize these via ordinance, and who can do it, when, and where, then golf carts are not allowed on the highways of the state, okay? It also subjects golf carts to the open container provisions on highways. So no drinking, no open containers on golf carts anymore when they're on a highway. Now, a highway is not on a golf course, so I don't know how that impacts people who are actually out golfing. But if you ever take your golf cart to cross a road or anything else while golfing, and you have an open container on there, you will be guilty of an open container violation. So just be aware of that. Important stuff, Bob, with these golf carts.
Thank you, Tyson.
Senate Bill 197, consanguinity amendments. In 2019, you may recall, we made some changes to the cohabitant definition. And as part of that, we limited related by blood or marriage to within 2 degrees of consanguinity and affinity. The problem became, once that went into practice, that we didn't have a definition for consanguinity or affinity to the 2nd degree. We didn't know what that to the 2nd degree included, and in looking at other neighboring states and other states in general, there was not a uniform interpretation of what to a 2nd degree included. So we now have that. And affinity is defined as a relationship by marriage, and consanguinity as a relationship by blood to the 1st or 2nd degree, including an individual's parent, grandparent, sibling, child, aunt, uncle, niece, or nephew. Interestingly, this discussion began by one case that I became aware of, where an uncle was intervening against an abusive nephew who was abusing this uncle's sister. And as we move into the baby boomers and an increased elderly population or older population, we're going to see more of these dynamics and this elder abuse occurring. And so we needed to make sure that we could protect, within the aunt and uncle relationship as well under the 2nd degree.
House Bill 324 is about conviction integrity units, and this image is out of Long Beach, California. It is a recent exoneree. Conviction integrity units under this legislation are a tool that prosecutor agencies can choose to implement to play a role in making sure that not only we can secure convictions, but the convictions we do secure are appropriate. This bill does not require the creation of CIUs. It simply creates the option or a statutory framework. Salt Lake County does have a conviction integrity unit. Utah County has discussed creating one in past years. There are limits to the authority of CIUs. CIUs can only investigate their own cases or their agency's own cases, or cases specifically requested by a prosecutor who does not have the resources for his or her own conviction integrity unit. So if you're from a smaller jurisdiction and you like the idea of a CIU, but you just don't have the resources, if you find an agency that does have a CIU, you can ask them to specifically look at the case. Now, what happens when the CIU looks at the case is they issue findings and recommendations. Those findings and recommendations are not binding. They go back to the head prosecutor, and the head prosecutor decides what action to take, if any. They can file a petition they file a motion with the court. The AG was consulted, and we negotiated with the Attorney General's office on this legislation because of the role they play in the Post-Conviction Remedies Act. And so this legislation gives another remedy for those infrequent but important situations where a conviction may not have been achieved with integrity.
I'm going to go through just kind of quickly. There's a couple bills that are down the line that we really want to get to. Realize House Bill 300 creates the opportunity for a county justice court to get territorial justice court over a situation that may have happened in a city where there is a justice court. You'll want to look into that and see where that applies and the restrictions on that. But there is a chance for a county or district attorney to file charges in their county justice court as a misdemeanor that normally would go to one of the city justice courts.
Another quick cover is Senate Bill 237, aggravated kidnapping amendments. The statutory language before referenced serious bodily injury to another during the commission of the offense, and that's now been expanded for clarification, serious bodily injury to the victim or another during commission of the offense.
Mail theft used to be based on the value of the mail, and unless you were ordering a Nintendo Switch on Amazon, your mail is monetarily worthless, but it has a lot of important information on there. Under this bill, the penalty for stealing junk mail is a Class A misdemeanor. For stealing mail with your name on it is a third-degree felony, and if you've got 10 people's mail, it's a second-degree felony.
This is an important change that happened here in Senate Bill 173. I'll hit on it real quickly for disorderly conduct. It basically takes the old disrupting legislative or official meetings section and repeals it. And it puts these provisions in the disorderly conduct section. Okay, so any disruption of official meetings, legislative meetings, disrupting in a public place, which is now defined in there as well, all are under the disorderly conduct statute now. The one thing I really want you to be aware of, however, is that if there is a request to desist, so disorderly used to be an infraction if there's no request to desist. If there was a request to desist, a Class C misdemeanor. If there is a request to cease your conduct, which is being disorderly, it now starts as a Class C misdemeanor still. However, if there's another violation within 5 years, it becomes a Class B misdemeanor. If there's a second or subsequent violation of the disorderly conduct where there is a request to cease the conduct, that's a Class A misdemeanor. This does not only apply to the disruption of public meetings, it applies across the board in disorderly conduct. So you might have somebody who's being disorderly regularly that you might be able to charge with a Class A misdemeanor now, where we used to only charge them at best with a Class C misdemeanor.
Senate Bill 238, battered person mitigation amendments. This bill allows a defendant who is a victim of abuse. So we're charging someone who is a victim of abuse who commits that crime against his or her own abuser to claim mitigation. This would result in a one-step reduction. It has to be proven by clear and convincing evidence that the victim committed the offense, or the defendant, victim, committed the offense against the cohabitant. I'm going to say abuser in this just for clarity, against the abuser, that the abuser had demonstrated a pattern of abuse against our defendant or another cohabitant of the defendant, and that the defendant reasonably believed the criminal offense was necessary to end the pattern of abuse. So for purposes of this statute, cohabitant is expanded to the parent-child relationship, which is not within the definition of our standard cohabitant definition. There's also a reasonableness definition that's a hybrid objective-subjective analysis. Couple practice pointers. In order to trigger this, the defense must file within outside of 30 days, give 30 days notice filing that they want to claim mitigation. Also, when the case is tried before a jury, it will be based on unanimous jury verdict through a special verdict process as to whether or not mitigation was found. So they will make a determination, the fact finders will make a determination on guilt or innocence. And then if there is a determination of guilt, they'll make a determination as to whether or not mitigation is a factor. If they do not find unanimously that mitigation is a factor, then the guilty verdict is entered and the level of offense remains unchanged. One word of caution with this. This should in no way be construed as permission or condoning charging our victims of domestic violence. I think that we will actually see this in play very, very rarely, as it should be, very rarely. More often, I think we're going to see it as defendants, abusers who are trying to wear the victim hat and get the benefit of a reduction. But please be cautious in this. We should not be charging our victims of domestic violence wherever possible. There are fact scenarios and extenuating circumstances where that may occur. But this in no way gives that broad overview of, hey, go ahead, charge them even though they're a victim, because they can get a reduction through this mitigation process. Don't do it.
As we're flying through at the end, I'm going to repeat what Tyson said at the beginning, and that's read the legislation. Our whole goal here is to get you interested, but they're a lot more complicated than we have time to talk about. Let's talk about body cams. The law requires police to record certain incidents on body cams. Sometimes police have not been recording that when they're statutorily required. This bill outlines what remedy defendants could have. It also allows officers to turn off body cams when they're performing a lethality assessment. So that you're aware, law enforcement, if you intentionally or with reckless disregard of what the statute requires turn off your body cam or fail to turn it on, a judge can give an adverse inference instruction against you as the officer. And the prosecuting agency needs to let law enforcement know when a judge has done that adverse inference instruction under this bill.
Any other bills that either of you for sure want to get to in our last 2 minutes?
Just a quick comment on HB 298, the victim guidelines for prosecutors. That has to do with U visas and T visas. Go through it and read it. I just wanted to make an emphasis. We have law enforcement and prosecutors who struggle in signing these because they don't want to be giving permission for someone to get status in this country. That is not what your signature means. This is just signing off on one piece of a vast amount of information that gets analyzed before someone gets legal status. This is specific to domestic violence cases. We do not want to be part of creating or holding up obstacles to them being safe and potentially getting the status that they need. But we're just one small part of it. So take a look at those, follow the guidelines, and sign wherever possible.
House Bill 43 addresses the discipline dance that some officers were engaged in, where they were facing discipline that might have subjected them to getting in trouble with post, and so they offered to quit or they retired before they could get disciplined, and post never found out about what happened. They would then go to another agency without that new agency knowing about any of the previous problems. House Bill 43 says even if an officer resigns or retires, if the underlying offense would have been one that has to be reported to post, the employing agency needs to report it to post after the resignation or retirement. So it's to address the discipline dance that some officers were engaged in, especially those that we don't want involved in law enforcement.
Realize that the perceived loophole in fringe gambling, and we're not clicking through our PowerPoint slide anymore because we're way out of order here, but has been closed, and they've really strengthened that. So if you are seeing those machines in any of your gas stations, you shouldn't have any problem enforcing those anymore and be able to go do it.
Salt Lake County and several other agencies have been sued based on the new language of the legislation, so the closed loophole may not be totally closed.
It may be unconstitutional.
Yeah. Stay tuned.
But there's a lot more here. Our materials are online. The legislative summaries are online. If you have questions, our contact information is actually in the PDF on the last slide in our presentation on the line or online. Contact Will or Marlise or myself if you have any questions. We're happy to talk to you and help you. There are still many more that we didn't get a chance to go over, but good luck over the next year, and hopefully we'll see you in person next year.
Stay healthy.
Okay, we have 1 minute. So I know some of you were going to email me about what Tyson was talking about, e-prosecutor. So let me just tell you where we're at in terms of that. We ran out of licenses under the original grant, 150 users. I am in the process of drafting and submitting a new grant proposal to CCJJ. It's due next month. I'm going to start working on it next week. As Tyson indicated, CCJJ has indicated that they appear to be willing to work with us to facilitate this grant application, get it approved so that we can purchase additional licenses. So for those of you that don't have e-prosecutor currently but are hoping to get it, I'm hoping that we will be approved on the grant. I will find out late in the summer, early fall, if that has been approved, and we'll let you know. Excuse me. E-prosecutor currently has the ability to track, I think, most of the data that Tyson mentioned. It may not be active, meaning that those drop-down boxes may not be active, but we think we can turn them on, or as Tyson indicated, we will contract with Journal to create those options. What that's going to require, though, is, again, as Tyson mentioned, if you receive e-prosecutor under the grant funding, certainly new funding, possibly under the original grant that we got, if you are not reporting that data, then you're going to have to pay CCJJ back the value of e-prosecutor. So just be aware of that. So hopefully that answers questions. If you do have any additional questions, please go ahead and email me. With that, let's take a 15-minute break. We'll be back at 10:45 with Jamie for the civil.